So the format of today is going to be that the four of us are going to try and get through as many cases as we can effectively from the year, covering 5 of our practice groups in chambers. First of all, cross-border disputes, that's me, followed by Richard talking about personal injury cases, and then after that, Lisa speaking on the subject of clinical negligence, and then Conor rounding up with property and professional negligence. During the course of our speaking, there's obviously going to be one person speaking, 3 people muted, and there is a Q&A function, there's a chat function, so if you want to chat with us, just stick something on the chat. Otherwise, if you've got any questions about the cases that we're talking about, if you Q&A as we're going through, or if you prefer at the end. You can stay anonymous if you like on the Q&A, or you can tell us who you are. The only trouble with staying anonymous is that if you ask us an anonymous question and we don't get to it, obviously we can't come back to you with the answer to the question later because we don't know who to come back to. So it's the usual thing. The webinar is being recorded. It will be on our YouTube channel along with all the others for all posterity, and the slides will be sent to you after the webinar. I think I've now said everything that Emma told me to say before the webinar. And we probably ought to start on time, actually. Usually we give a 5-minute grace period for people to come in, but I think actually we probably ought to start on time because we've got quite a lot to get through. Effectively, we're trying to get through as many of the cases from last year as we possibly can in as many of the practice groups as we possibly can. Apologies if we've missed out one that's terribly important to you. If you think that we have missed out one that's terribly important in our area, then put it on the chat so that everyone can see it, or on the Q&A, ask us why we haven't referred to it. And we will refer to it at the end, just so that everybody knows what is happening, and we are sure that we've covered everything we ought to be covering. Oh, Dom's here. Hi, Dom. We are obviously looking festive. We've made enormous efforts, particularly Richard, to get ourselves Christmas jumpers, and we're all in the mood for Christmas. So we thought a little message wishing you a Merry Christmas and a Happy New Year, but let's not go nuts. And in that vein, I shall start. I see people still coming in, but I'm afraid they have missed their chance, in reliance on our 5-minute grace period usually, but I feel I ought to get started because otherwise I'm going to eat into Richard's personal injury time, which would be a tragedy. So what's been going on in the cross-border world this year? Those of us who practice in this field with claims with a foreign element have obviously been extremely busy this year, and the 2 major things that we've been busy with are actually things that we haven't really had cases about. The reason for that is that one of them we are only midway through, and the other one we are just about to start. Of course, I'm talking about COVID and Brexit. And for those of us who work in this field, it's been something of a perfect storm because the COVID pandemic and the measures that were taken in order to try and contain it have given rise to an enormous amount of difficulty in the travel sphere. So refunds from airlines, refunds from tour operators, refunds from accommodation suppliers, refunds from hoteliers domestically, and so on and so forth. There are also all of the issues around insurance, business interruption insurance, which Richard and I have been speaking on quite a lot lately, and also other refund insurance, which again, Richard and I have touched on quite a bit, certainly at the beginning of the COVID pandemic and more latterly. I'm not going to say anything about those because it's a case law roundup, and we haven't yet had any cases on those other than the FCA test case on business interruption, which Richard and I will be speaking about in the new year next year. So because that's still going through the Supreme Court. So if you've tuned in for business interruption insurance, I'm afraid you're going to be disappointed, but our previous webinars are all available to view. So that I point you in that direction. In relation to the COVID pandemic, it looks as if we are making progress to get through that, but with every passing stage that we go through, so going through lockdowns, going through tiers, going out the rollout of the test and trace, the rollout of the vaccine, all of those stages have brought with them their own problems about which we have all been advising during the course of this year, insurers, tour operators, and so on. But those are issues which I venture to predict are going to be really, really important next year and the year after. The thing that's really important at the moment is Brexit, because we are, again, really, really busy, all of us, doing pre-Brexit claims. And we will then be, in a couple of months' time, really, really busy doing pre-Brexit defences to claims. If any of our participants still have any claims with a foreign element, which need to be brought directly against a foreign insurer, or indeed against any foreign entity, you need to issue them right now, before the end of the year. And that's something that I've been saying for probably 3 months, is it, Rich? It has got to be 3 months I've been telling people to issue their pre-Brexit claims.
At least, it feels like forever.
It does feel like forever, but that's really, really important. And if you take nothing away from this case law update, other than that, it's still worth doing. Turning then to the authorities that we have had this year, as opposed to the ones that we will inevitably get next year when the Brexit fallout comes into focus. What have we had? Well, we've had loads of stuff in the foreign element field. First of all, package travel regulations. We've got 2 lots of those going on at the same time at the moment. So some of our holidays that we're looking at have still been booked under the 1992 regulations. Those are the ones that were booked before July 2018. So there's still, that runoff is still occurring. Then the ones after July 2018 are then covered by the newer package travel regulations. But in relation to both, there is a need in relation to accident cases for the claimant to prove a breach of local standards. So if you go abroad and you fall over in a Spanish hotel, you need to show that the Spanish hotelier has done something wrong by reference to local standards. And then the tour operator will then be liable for that breach of local standards. There have been a couple of cases this year that cast that cardinal principle into some doubt. And that's a principle that we have all been working under since a case called Wilson in 1993. The 2 cases that you see on your slide cast that into doubt. The first is an application to set aside default judgment. And the defendant said, well, we do have a good arguable case. The defence, we ought to be allowed to enter a defence, and our defence is a defence of local standards. Judge did not accept that. It's, I think, a master. I think Chris Deacon's here. He'll be able to tell us whether it was a master or not. I think it was Stuart's case, where the application to set aside default judgment was not allowed because the judge said, well, it's not for the claimant to prove a breach of local standards when I'm considering this. This was in relation to an aircraft that fell off a runway. And the judge said, well, look, it's perfectly obvious that that shouldn't be happening. But furthermore, it's for you to bring any proof that you may have that there isn't a breach of the requisite standard. You haven't, and therefore you can't have the default judgment set aside. So that was the first case that seemed to cast some doubt on whether or not the claimant actually needed to show a breach of local standards. Second case, much more stark, that's the Morgan and Toohey case, where there was evidence that there was no local standard. This is a lighting case. And each party had evidence of local standards, and each of those experts came to court cross-examined and said, yes, there's no standard in relation to lighting in the location where this accident took place. The claim nevertheless succeeded because the judge said, well, I can extrapolate from the standard that would have been in play had the accident taken place somewhere else. Now, for what it's worth, I think Morgan and Toohey is probably wrong. It certainly upset what we all thought we knew about Wilson and best travel in 1993. And I think I don't know it's being appealed. It ought to be appealed in my view, because I think it's clearly wrong that you can extrapolate from evidence as to what would have been the standard somewhere else to say, well, that's the standard here. So, for example, emergency lighting can then extrapolate into non-emergency lighting. So we've had quite a busy year in relation to local standards, and we have the orthodoxy is beginning to be upset a little bit by both of those cases. Ex and Cuoni, which is a case that's been going on for some very considerable time, is rumbling ever closer to some form of conclusion. There are 2 very long ongoing cases in the travel sphere. First is Ex and Cuoni, the second is Brownlee. We had some developments on each of those, but we are nowhere near the end of either of them. And I slightly suspect that even Richard won't have retired by the time we get an end on Brownlee and on Ex and Cuoni. But Ex and Cuoni, the thing to note about that is that in a vicarious liability case, this was a sexual assault case where the person who was assaulted tried to hold the tour operator liable for that assault. and the tour operator said, well, it was an unforeseeable event that the employee would do what they did, that defence in Regulation 15 of the 1992 regulations was not available to the tour operator in the circumstances in which this event occurred. It's only the Advocate General's opinion. I always thought that X and Q only was wrongly decided, so I'm delighted to see that somebody else agrees with me. And we will see whether or not the European Court of Justice accepts that. In relation to food poisoning claims, we have had a really major development, Griffiths and Toohey. This was a case where a microbiologist's report was challenged by the defendants, but had not been controverted. And there is a determination between those two things. So effectively, the defendants said, well, we don't accept this report, but they did not ask questions of the expert. Did they ask questions, but he didn't answer them? I think that's what happened. So there were no answers to questions in that case, and he was not called for cross-examination. The judge said, well, in those circumstances, I'm bound to accept that evidence. And this is a case, Griffiths and Toohey, which applies across the boards to expert evidence. There's no reason why that should apply only to food poisoning evidence. So where you have got an expert report and there is nothing which undermines it, and all you've got is the submission that it's not a very good report, that report will be accepted, other things being equal. That case, it seems to me, again, is wrong. I do tend to disagree with judges. I don't know why that should be, but it seems to me that case is wrong and it is being appealing. So how long that's going to last for, nobody knows, but it is something that's quite useful for claimants in the food poisoning world who have been having quite a torrid time of it the last couple of years. In relation to private international law, we've had a number of questions on jurisdiction answered. Hutchison and Matfray, territorial clauses are not effective. So these Spanish insurance clauses, which only kick in when a claim is brought in Spain, do not work. There was then a European Court of Justice case which ducked that question. So it's ongoing in Europe, but certainly in England and Wales, we have answered that question. They do not work. And in relation to the senior taxi case, the claim against the anchor defendant must be a sustainable one in order to anchor other defendants successfully. Related proceedings, we've had a number of Italian torpedo type cases this year. Again, you see on the slides what the case is held. The court second sees can consider whether it does have jurisdiction or not, which is something that is probably new to us. And joining criminal proceedings in one jurisdiction precludes bringing a civil action in another. And it's really important that we, those of us who act in European claims, bear that in mind, because in a lot of the European jurisdictions, you have hybrid criminal civil claims, and the claimant can be added accidentally to those claims. So it can be added automatically to those claims, and it does preclude bringing a civil action in England and Wales in those circumstances. Extant proceedings, this is to do with the French proceedings, where it's a sort of provisional damages type situation where you can come back for more in France after the end of proceedings, but those proceedings are not still extant for the purposes of related proceedings if the civil aspect has been dealt with, if the first aspect has been dealt with. On pleading foreign law, you don't need to. I think we all knew that because of Bumper Corporation, but again, Brownlee, another development in that, and the Qatar Airways case also found failure to plead foreign law is not fatal at the jurisdiction stage. So all you have to do is make a bare assertion about what foreign law is, and you need not plead the chapter and verse on it. So what the specific provisions are, you don't need to plead. In relation to applicable law, you can increase some heads of loss to reflect undercompensation under others. So this is the Spanish case where under the Brainmo tables, you get a range of awards possible under each head of loss. And the judge in that case held the maximum for some heads of loss in order to reflect undercompensation under others. And that's going to be important in those areas of applicable law, such as Greek law, Spanish law, you don't get care, but you can bump up the personal injury aspect of things in order to counterbalance the fact that you're not getting some other heads of loss, which we would regard as being a good idea for you to receive. Lastly, I think, under the Civil Liability Contribution Act, I think we all knew this before as well, but the Act we now know specifically applies extraterritorially. So anyone who's bringing a claim within England and Wales can bring a claim under the Act against a foreign supplier, for example, foreign defendant, foreign entity. So the Civil Liability Contribution Act applies to all entities all over the world as long as the claim is brought within England and Wales. And lastly, one of Conor's cases, Troke, English law is applicable to interest rates. So using the English discretion, you apply English law, which means that things like Spanish penalty interest at 20% is not going to be recoverable in England and Wales. For what it's worth, I think Troke's wrong, again, but you know, that is where we are at the moment. And I'm slightly hoping that we get some movement on that next year. I think I've taken a bit more of my time, but I have done a lot of cases in 15 minutes. Over to Richard.
Thank you, Sarah. I should say at the outset that this is the first that I've heard about us doing the business interruption update in the new year. I didn't know we were doing that. Great. I'll probably look in my diary and find that you've overridden my input into my own diary and just arranged it for me, which is brilliant, because the last time was just really low effort.
You've taken out a 5-day High Court trial so you could do it. Is that okay, Richard?
Oh, that's all right. No, it's fine. Yeah, brilliant. Good.
Right.
Great. Oh, yeah, and it's on the 1st of January or something. Yeah, that'd be classic. So I will speak as quickly as I can. The first two decisions there are both Supreme Court decisions this year on vicarious liability, quite helpfully addressing separately the two different stages of the test. So one concerning, so Barclays concerning the nature of the relationship between the tortfeasor and then the putative sort of holder of vicarious liability. The second is the actual conduct committed by the tortfeasor and whether that falls within the field of activities entrusted to that employee. So beginning with Barclays Bank, I'll be as quick as I can. This is actually a Chambers case, brilliantly. It was a group action brought by 126 claimants against their employer, Barclays Bank. The question was whether the bank was vicariously liable for alleged historic sexual assaults against the claimants by a Dr. Bates, who was a self-employed medical practitioner who the bank used to perform medical assessments and examinations for their prospective employees. I can't go into the facts in the detail that I'd like to, but there was a lot to do with where he performed the examinations, what instructions he was following and things like that. It was a very fact specific, as all vicarious liability decisions are. It was very fact specific. Now the claims succeeded at first action, and then were that decision was upheld by the Court of Appeal. The Supreme Court, however, allowed Barclays' appeal. Lady Hale gave unanimous judgment. Going through the reasoning as quickly as I can. So historically, as we all know, vicarious liability is limited to employer-employee. Lady Hale explained that that's now expanded and it covers relationships that are akin to employment. And that's the key word, they're akin to. The claimants argued that the law has expanded considerably in recent years and is on this movement towards greater expansion. Following cases like Christian Brothers and then particularly Cox and Arms over the last sort of, I think, 3 years or 3 or 4 years. Barclays, however, relied on what is known, what historically has been known as the independent contractor defence. So saying as an employer, we can't be deemed vicariously liable for this person because they're an independent contractor. That's exactly why we don't employ them, or one of the reasons we don't employ them is so that we're not liable for their actions. They are independent. Now, Lady Hale concluded that Dr. Bates was not at any time anything close to an employee, rather he was in business on his own account. But as I've said, that was with regard to, or with sort of very close consideration of the facts in this case. And that really must be emphasised with vicarious liability, that these general decisions are helpful. They should always be your starting point for what are the applicable principles here. But if you're dealing with a case, with anything apart from very clear, very established vicarious liability, you need to go further with your research and try and find a case. It'll probably be High Court, that covers as close to your situation as you can. And there is an enormous amount of case law out there on vicarious liability. I know this from having advised on it recently. There's just masses of cases, and you have to go through them and find the one that most closely covers yours. Moving on, the Morrison's decision, the other aspect of the other prong of vicarious liability. This was an employee of the well-known supermarket chain Morrison's, who worked in the internal audit team, and he was given a verbal warning after disciplinary proceedings for minor misconduct, which you may think not a big deal, move on. He decided, however, to pursue a particularly bitter vendetta. So when he was later asked, or when he was tasked with transmitting payroll data for the entire workforce, he made a personal copy, then uploaded that to the internet and sent it to 3 newspapers, which I may use if Sarah continues her campaign of just hatred against me. I may consider similar tactics, but not just yet. Now, primary, so I should add, the claims were brought against the bank, sorry, not the bank, the supermarket, both for primary liability and secondary vicarious liability. At first instance, primary liability was dismissed, but vicarious liability was allowed. That again was upheld by the Court of Appeal, with heavy reliance being placed on Lord Toulston's judgment in Mohammed, and that was the petrol station case with the attendant who assaulted the customer. Lord Reed, however, gave judgment for the Supreme Court, unanimous judgment, allowing the appeal and making clear, and this is probably, I think, maybe where this decision's most helpful, most important. He made clear that Lord Toulston's comments in Mohammed were not intended to change the law. Rather, they followed existing precedents. So when you're considering this question, you can't just look to Mohammed and say, well, it covers everything now. Look, this guy assaulted someone and that was covered. You need to go back and consider the pre-existing precedents as well. The key one in this case being Dobie aluminium and the close connection test of whether the wrongful conduct was so closely connected with the actions of the actions that the employee was authorised to do that the employer can fairly be held to be liable. The question that then arises out of that is, what were the field of activities entrusted to this employee? So that's what you need to do, is rather than just looking at other cases and saying, oh, well, assault was covered in this case, so it must be covered in ours. No, your first question needs to be, what were the field of activities that were entrusted to this person? And then move on from there. In this case, the disclosure of the data was not part of the employee's field of activities. A temporal or causal connection alone is not sufficient to satisfy the test. And it is, crucially, it's highly material whether the person was acting on for the employer's business or purely for personal reasons. So those are the 2 vicarious liability decisions. I'll be as quick as I can going forward. Sarah, is it all right to move on? Thank you. 3 claims there. I'll rattle through them. I'll begin, if I may, just with how my notes are structured, with Swift and Carpenter, which is accommodation claims. This was the Court of Appeal considering special damages claims for accommodation, specifically the correct method. So as we all know, with accommodation claims, where somebody, as a result of injuries that they've sustained from somebody else's negligence, if they require a more expensive property, if they're simply given the additional cost of acquiring this new, more expensive property, their estate receives a windfall upon their death, because there's no longer the need for the special facilities that the extra cost represented, yet the extra cost is still in the belonging of the estate. Historically, or well, not historically really, but prior to this, Robertson Johnstone was the applicable authority which devised a particular calculation method to compensate for that windfall problem. The problem then with that method was that negative discount rates produced a nil sum for these claims using the formula there. Lord Justice Irwin gave lead judgment. To summarise, he proposed an alternative method which is based on reversionary interest, which really means you award the full additional interest to the claimant. You then deduct the value of the reversionary interest, which is the value that the compensator would have in the property if the additional value were to revert back to the compensator upon death. So it's a little bit complicated. In terms of what that value actually represents, quite interestingly, actually, there is a market that exists, a small market that exists for these interests already. So they took expert evidence on that market and said, oh, it's around 6 or 7%, but they said they should be more cautious. So they narrowed it down at 5. There's a formula for doing it, but I don't have time to go into it, fortunately. But Sarah, I'd love to go into the formula, but I can't. Barlow and Wigan, I'm going to have to rush through this. It's a highways decision. It's a claimant who tripped on a public path or a path in a public park. The question was whether the path was a highway maintainable at public expense. The lines of reasoning employed in the case, for those of us who enjoy highways law, which I do, the lines of reasoning are really impressive and really sophisticated. I can't go into them again here, fortunately, but Roddy Abbott of these chambers wrote a brilliant article on it in our highways briefing. I think it was a month or so ago. In short, the claim was successful on the basis of so-called deemed dedication. And the question in that case was looking back in time to 1949 when a particular statute came into force and asking, don't know what that means, asking whether there was evidence at that moment in time of continuous and unobstructed use over a long period. So the significance of this case is that I think it shows the court being prepared to recognise more unconventional claims against highways authorities. So if you receive an unfamiliar claim like this, look to Barlow and go from there. Finally, Roberts against Kesson. This is fundamental dishonesty. It's a motor claim, but it would apply to all PI. I'm not going to go into the facts of it. Essentially, this is a high court decision. The principle is that where a claimant brings a claim, for example, ahead of loss, which is later known to be dishonest or later found to be dishonest, but they didn't pursue with that dishonesty at trial. So they do, for example, a witness statement and schedule of loss. And that gets pointed out by the defendant through investigations that it was dishonest. The claimant then realises that, drops it before trial and doesn't pursue it. That doesn't matter. If they sign the witness statement, they sign the schedule of loss, if that is shown to be dishonest, then that can form the basis, and this is where it's important, of a Section 57 finding, which means that you dismiss the whole claim, and there's then an enforceable cost order subject to what the damages would have been subtracted from the defendant's costs. But yeah, so where dishonesty isn't pursued at trial can still form the basis of Section 57. That's me done. I'll move on. Thank you very much, everyone.
Thanks, Richard. I've just had a notice saying my microphone isn't working properly. Can you all hear me? Wonderful, very good. So moving on to the clinical negligence cases, I've chosen 4 cases across the year covering different aspects of liability. I'm going to start with ABC and St George's Healthcare. I've called it breach of duty, but I probably should have called it duty of care because that's really what this case is about. I counted up the cases on breach of duty across the last 12 months, and there have been about 10 reported cases. It's really quite interesting how the very well-trodden Bolam and Bolitho tests still keep producing reported cases that are interesting. We keep getting new facts and they are relevant and you have to stay on top of them. ABC and St George's Healthcare Trust is a very interesting one. You may recall it from 2015 where it was struck out and then on appeal that was quashed and it was remitted to trial. The facts are described as being very tragic and unusual, and that is right. It involves ABC, the daughter of a man who murdered his wife. And then he was prosecuted for manslaughter, diminished responsibility, and was incarcerated. His daughter ABC and another daughter were then, they went into family therapy because of the effects of the tragic events. And whilst they were receiving counselling, their father was tested for Huntington's disease a genetic and incurable disease, and he tested positive. And at the time that he tested positive, he didn't want his daughters to know about it, and ABC was actually a few months pregnant. His confidentiality was kept, and they weren't informed of the Huntington's disease, but ABC was informed after the baby was born, and a few years later she herself tested positive for Huntington's disease. And the question was whether there was a duty of care owed by various parties to her to disclose and override the confidentiality. I think originally the particulars of claim were against the geneticists treating the father, against the hospital who were detaining father but also providing counselling to the daughters, and also against a social worker. The claim against the social worker fell away, I think, at the strikeout stage, and the claim against the geneticist failed in the High Court. But this decision looks at the duty of care owed by the second defendant, and that is the hospital detaining father and providing treatment to the daughters. It's a fascinating judgment, worth reading in full, and probably would be the subject of a 45-minute seminar, webinar on its own. But the court did find that there was such a duty of care in circumstances where that's never been found previously. It was a careful balancing exercise between overriding the confidentiality of father versus the needs of ABC, because it was brought just by ABC, one daughter. And on the usual proximity, foreseeability, fair, just and reasonable, it was found that all of those were satisfied in this case. The context in which family therapy was being provided was very important, because it established that proximity between ABC and the second defendant, because they weren't just detaining father. However, having gone to the length of finding a duty of care, the court went on to find that when applying the facts to the test, in this case, there was no breach of duty, and that even if there had been a breach of duty, there wouldn't have been causation. And with regard to the breach of duty, it was quite interesting that what they said was that the decisions of the second defendant trust couldn't be described as illogical. It wasn't straightforward whether to disclose that information in this instance. And in fact, it was quite interesting that they referred to the fact that ABC herself, when she discovered that her father had Huntington's disease and then discovered that her sister was pregnant, she formed the view that her sister shouldn't be informed. And that was a careful balancing exercise made by her. And one of the comments of the court was it would be quite unfair to then hold different standards to the second defendant in circumstances where she had a very careful and difficult balancing exercise as well. So very tragic and unusual facts. Who knows whether a similar case would be, a duty of care would be found, but it's quite obvious that the limiting factors of the proximity test and the limiting factors of actually finding a breach of duty in such a careful balancing exercise means that this is unlikely to open the floodgates. Oh, next slide, please, Sarah. Thank you. Causation. I think I counted up about 6 cases over the last 12 months on causation. What I will say, for those of you dialing in that do practice in the area of clinical negligence, later this week we are publishing a briefing of a full yearly legal update. So you'll have all of these cases covered in a great amount of detail, and if you have any questions arising from them, then do just let us know and we'll do our best. But the one I've selected in relation to causation, mostly because I find it a bit of a head scratcher, is Shembry and Marshall 2020. It's a Court of Appeal decision, and it upholds the first instance decision of Stuart J. And it looks at this point. It says that Stuart J had not fallen into error when asking, when looking at the evidence as a whole, is it nevertheless more likely than not that the claimant would have survived had she been referred to Southend Hospital. So briefly, the background facts were that there was an admitted breach of duty by a GP. The claimant had presented with symptoms that should have warranted her being referred to hospital. She died later of a pulmonary embolism. And there are general statistics that are relied upon in these cases to show that if you are referred to hospital earlier, then your prospects of survival or a good outcome are actually very good. But as we all know, when we're looking at clinical negligence cases and we're looking at pleadings and the case presented against us, we look at it on a very micro level. So you go to hospital at this time, what would have been the examination results, what would the treatment have been, or the range of treatment, and what would the likely outcome have been? And then that might throw up another alternative scenario, and you look at that scenario on a micro level. What Schembri and Marshall does is takes it all back to the macro level and says, well, we can't actually identify which of those treatments, if rendered at what point in time, would have prevented her death. But the claimant doesn't need to prove that. All she needs to prove is, am I satisfied when looking at the evidence as a whole, would she have had is she likely to have survived? And there's some commentary within the judgment that if it had been just over 50%, then the judge might not have been persuaded. But because there was such convincing statistics of good survival rates with earlier treatment in hospital, he was so persuaded. I will just read a little bit from one of the cases that was relied upon. It's Drake and Harbour 2008 Court of Appeal decision. And this was at the forefront of the claimant respondent's argument. And it says, in the absence of any positive evidence of breach of duty, merely to show that a claimant's loss was consistent with the breach of duty by the defendant would not prove the breach of duty if it would also be consistent with a credible non-negligent explanation. But where a claimant proves both that a defendant was negligent and that loss ensued, which was of a kind likely to have resulted from such negligence, this will ordinarily be enough to enable a court to infer that it was probably so caused, even if the claimant is unable to prove positively the precise mechanism. That was upheld unanimously in the Court of Appeal, that approach of looking back and taking the macro level approach and asking yourself, well, is this a kind of injury that's likely to have been caused by the breach? And overall, would they have been likely to survive? Looking at the general statistics, it was enough in that case. Now, the Court of Appeal stressed that this was a very fact-sensitive case, and that this is no new principle of causation. But for those of you representing claimants, you need to be aware of it and you need to be using it. For those of you representing defendants, you need to be aware of it and be guarding against it. With your experts, you need to be looking at what we're used to looking at, which is the micro level analysis of causation in the report, but also take a step back and look at the macro level and ask yourself whether there was an overall very good chance that the patient would have survived if the treatment that was not provided because of the breach, if that had been provided, would they have had a good prospect of survival? Because there's authority here that will get them home. Could I have the next slide, please, Sarah? Oh, and the next one. I've gone on twice, thank you. So this is a secondary victim case. I think it's the only reported secondary victim case over the last 12 months. And it featured Laura Johnson from our chamber. She represented the claimants, Paul and another in this case. It's a very good judgment by Chamberlain J. You need to read it. It gives a really good summary and analysis of all of the complicated secondary victim cases that we have seen over the years, and the kind of contraction and expansion of the principles. There have been a flurry of cases over the last 5 years, I would say, contracting the principles and making it much harder for claimants and much easier for defendants. But this is an interesting case because of the way that the arguments have been presented. I won't pretend to do it justice in a few minutes, but we do have a webinar on our YouTube site which was provided by Eddie Bishop QC and Laura Johnson, who I say represented the claimants. If you're interested in particular in this, then go and have a listen to it. The case was struck out at first instance by Master Cook, I think, and he said, in the circumstances, the second and third claimants' secondary victim claims are, in my judgment, bound to fail. Mr. Paul's tragic death 14 months after the negligent incident, in circumstances separated in space and time from the negligence I must assume occurred in the hospital, cannot possibly be said to be the relevant event for deciding the proximity required to establish liability under the established control mechanisms. Very briefly, the facts of this were that the deceased had attended hospital in 2012 with chest pain and jaw pain. An angiogram wasn't performed. If it had been performed, it probably would have revealed that he had coronary artery disease and he would have been treated for it. 14 months later, he was out shopping with his two daughters and suffered a catastrophic and fatal heart attack. And they witnessed the event of that, which was him collapsing, ambulances attending, chest compressions, and a traumatic external event. And what was pleaded in the case was that that event 14 months later was the first manifestation of the breach of duty. And if that was right, then all of the other Alcott criteria that we see in secondary victim claims were satisfied. Master Cook wasn't persuaded of that, but the High Court was on appeal. I've listed some of the arguments made by the defendant and respondent in that appeal, which essentially failed. And it turned on the case of Taylor and Novo that you'll see there. And what Chamberlain J said was, I would therefore hold that the principle in Taylor is no bar to recovery in this case. If it's shown that Mr. Paul's collapse from heart attack on the 26th of January 14 was the first occasion on which damage caused by the hospital's negligent failure to diagnose and treat his heart condition became manifest, then it succeeds. So they looked at the defendant's argument about the temporal association, and they said, well, the event isn't the breach that occurred 14 months previously in hospital. The daughters didn't need to be proximate to that event. They needed to be proximate to the external manifestation 14 months later, which they clearly were. So they rejected the defendant's argument in that regard. The defendant also ran an argument that it wasn't external, sudden or shocking, and tried to interpret external as that the event was internal to the father. But of course, the event was the sudden shocking collapse, which was of course external, and we see that frequently in previous case law, and that the manifestation was, even if there was something occurring internally, the first manifestation of it was what happened 14 months later when they were out shopping. And so it's proceeding to trial in the usual way, and it's no longer struck out, and it's a very interesting judgment and worth reading. Could I get the next slide, please? And then I've chosen a quantum case. Thankfully, Richard dealt with Swift and Carpenter, and whilst he didn't deal with the formula, he did provide a summary which was much more elegant than I would be able to provide in about 2 or 3 minutes. So I've chosen Whittington, and why have I chosen Whittington? It's one of the only, I think it's the only Supreme Court quantum case in clinical negligence contexts this year. Edward Folkes QC of our chambers was representing the trust. It's a very interesting decision, and it's interesting for this reason. Could I have the second slide, please, Sarah? That I really love this, which is that the next question is whether it is possible to claim damages for UK surrogacy arrangements using donor eggs. In Bryody, so Bryody was a case decided in 2002, and I think it went to appeal in about 2004. It dealt with surrogacy. And there was less than a 1% prospect of the assisted pregnancy working in that instance, and the cost of recovering the costs of surrogacy weren't. It was determined that they were not recoverable. and Bryody was the plank of the defendant's argument in this case. And it said, in Bryody, this is Lady Hale, I expressed the view that this was not truly restorative of what the claimant had lost. It was seeking to make up for what she had lost by giving her something different. We need not concern ourselves with whether or not this view was technically obiter. In my view, it was probably wrong then, and it is certainly wrong now, which was a very bold statement for Lady Hale to make about her decision-making process back then, and where the law stood now. And I think it's a really interesting reflection of how the law can move on really quite quickly in about 18 years. If you look at the first instance and the appeal decision, because society's views have changed and public policy has changed around surrogacy arrangements. And because of that shift in public policy, there has been a shift in the law. And if we could just go on to the next slide. It was interesting that the Supreme Court did set out some limiting factors with regard to the recovery of these costs. So it covered whether or not you could recover for surrogacy generally, whether you could recover for the costs in this country, and whether you could recover for the costs in another country. The most controversial aspect of that was the foreign element, because these courts will not enforce a foreign contract if it is contrary to public policy. And whilst it's not illegal to enter into a contract in another country, it's not legal in this country to have a commercial contract for surrogacy. And so one of the arguments was that with regard to a foreign contract, it ought not to be recoverable because it's contrary to criminal law in this country. The Supreme Court disagreed with that and said that it isn't contrary to public policy, and if they want to go off and contract in another state, then they can do, but they impose these limiting factors. The proposed programme of treatments must be reasonable. In other words, there must be good reasons to think that but for the negligence, the claimant would have had the number of children now proposed. It must have a reasonable prospect of working. It was quite interesting that in Bryody, as science stood, the prospect of the surrogacy working was less than 1%, whereas now we see much better prospects of it working. But query what they mean. Does it have to be on the balance of probabilities? Does it have to be less than that? Can it be significantly more than that? And also that the costs involved must be reasonable. Just because it's permitted as a matter of law in another jurisdiction does not necessarily mean that it is reasonable. You have to look at how that actually operates in that country, whether it's properly regulated, and only in those instances will it be recoverable. Again, because Edward Folkes QC was representing the defendant, we have a number of articles on our website covering this case, much more elegantly than I can, but it's one worth looking at. But those are the 4 highlights that I've selected for the year, and you will be receiving the clinical negligence team's full legal update in a couple of days, right into your inbox. Okay, thank you.
Thanks, Lisa. So I've been tasked with representing the property team, but also, if possible, the public law team. So I've picked 3 cases to talk about. They're all property cases, but the second and third cases also have a public law aspect to them. So hopefully I've killed 2 birds with 1 stone. The first case I'm going to talk about is a case involving the illegality defence, which was in the Supreme Court earlier this year. It had, Morris Rifat and Andrew Warnock appeared for the successful respondent. They've actually, as with a number of cases that have been mentioned, they've put on a sort of 1-hour webinar, which is available on our website, which is goes into a lot more detail than I can in 10 minutes or 4 minutes for this case. But essentially, the facts should be relatively familiar to anyone who's sort of to anyone who's ever seen a mortgage fraud. There was an individual who used Morris's client as sort of a cat's paw, that is someone who's a tool to carry out some dirty work for them. This individual wanted to borrow about 75 grand from a bank. There was no bank that would have lent him that money for a number of reasons. He was a particularly dodgy character. So he got Miss Grandona to apply, first of all, to agree to buy some land off him for an inflated price of about 90 grand. They secretly agreed between themselves in a sort of illicit contract that she wasn't really buying the land, it was just a sham to get him a loan of 75 grand, and that he provided the purchase deposit and was secretly the buyer of it. Now, Stoffel & Co was a solicitor's firm who got mixed up in this. They weren't a particularly diligent firm. For example, it was remarkable that they acted for both the seller and the buyer, and it didn't occur to them, even at trial at first instance, that there'd been anything wrong with this. So not a great start. They messed up the registration of Miss Grandona's purchase, her purchase of this property. They failed to register the TR1. And as a result, a couple of years later, when Miss Grandona inevitably defaulted on her mortgage repayments, the lender came after her, and she sought, well, she didn't have any property interest with which she was able to raise money because of the solicitor's negligence. So she joined the solicitor firm Stoffel & Co. That then, can I get the next slide, Sarah? That then led to a 6-day trial in which the solicitors who hadn't covered themselves in glory saw the illegality defence as a possible way to escape the consequences of their negligence. It went up to the Court of Appeal. The trial judge, a circuit judge, rejected that illegality defence on the basis of Tinsley and Milligan, on the basis that Miss Grandona hadn't relied on her illegality in order to bring her claim. After that, the Supreme Court had handed down judgment in Patel and Mirza, which was in 2017. So the solicitors saw this as a possible get-out, appealed to the Court of Appeal, but were unsuccessful. It then ended up in the Supreme Court, and the Supreme Court there re-examined this trio test that had been set out in Patel and Mirza. So the underlying, when applying this sort of test, the court will consider whether the underlying purpose of the prohibition, which is being transgressed, they'll consider any other public policies, and then lastly, they'll consider whether the overall effect of allowing an illegality defence would be disproportionate. So, next slide. Looking at that on the facts of this case, actually, I'll skip on another slide. So, looking at the first stage, the effect on the underlying prohibition, the Supreme Court thought it would be slightly ridiculous, as indeed it must have been, to think that fraudsters would go through this mental process of wondering, oh dear, can I actually sue my solicitor for professional negligence if I get caught and need to bring a claim against them? It also had regard to the kind of perverse consequences that allowing an illegality defence would have punished the lender in this case, who was the only innocent party, at least innocent of negligence or fault. In considering the second stage, this question of broader public policy considerations, the Supreme Court agreed with Lady Justice Gloucester's view that there was a good public policy argument in holding solicitors and conveyancers to high standards, to high professional standards, and further that doing so would make fraudsters more likely to be caught. And then finally, at stage C, although it wasn't necessary to consider that because the appellants had fallen so far short on the first two stages of that test, it considered that it would have been grossly disproportionate to allow an illegality in this defence because of this issue of centrality, whereby the Miss Grandona's fraud hadn't been central to her claim. Because of course, at the stage, I'll just go on to the next slide, I think. Yes, no, previous slide. Yes, at the stage at which she'd instructed these solicitors, she'd already secured the loan and the money had already been drawn down. And further, she'd already secured equitable title, if not legal title, by way of the transfer. So, yes, the Supreme Court unanimously rejected that. So quite an interesting property case. As I say, I recommend the webinar. Morris has a very interesting sort of history of the case because he appeared from the first instance trial 12 years previously, all the way through. Very entertaining set of facts. So next case, Clark of Birmingham. This follows the Grenfell fire. I think this is a huge area of law for anyone working in property. It's an issue that the nettle hasn't yet really been grasped, but there is a huge reckoning in terms of the cost of remedial works which are necessary to either remove dangerous cladding or to install sprinkler systems in buildings that we now know aren't safe and that pose a huge lethal risk to the occupants of modern high-rise buildings. So the facts were that Birmingham City Council decided to spend £19 million on a sprinkler system. There was a tenant in one of these buildings who got very angry about this and thought, what a waste of taxpayers' money making a building safe for its residents. So he judicially appealed this decision to spend 19 million to make the block safe. And I'll look at the next slide. On the question of the value for money point, the Court of Appeal looked at whether they were it made a distinction between considerations that were necessary for to be taken into account and considerations that were permissible. Essentially, it took in the court found that that the council had taken into account all necessary considerations and Mr. Clark wasn't able to show that they'd taken into account any impermissible considerations. Looking at the next slide, I think it's also of some relevance to private landlords who have to take remedial works. There are going to be a lot of these who have service charge regimes. The discretion usually under these agreements or under these leases is very similar to the standard looked at in Clark. Although for residential tenancies covered by the 1985 Act, the court will also have to consider whether these decisions can be shown to be objectively reasonable. So the court would have had to consider whether the sprinklers were necessary or justified. Although, of course, I don't think you're going to find any judges who are going to think that taking fire precautions after what we saw happen at Grenfell is either not necessary or justified or not reasonable. So a very important decision of general application to property law. And also an interesting public law angle. So moving on to the next case, Alexander Devine and Housing Solutions. This is a kind of almost Charles Dickens Christmas Carol set of facts, because we've got this sort of very lovely children's cancer hospice charity pitted against a housing developer. Someone had left some land to a children's cancer hospice, and part of the land next to the hospice had the benefit of a restrictive covenant, essentially so that these children could play outdoors and enjoy their time and space and privacy of that land. Now, a housing developer acquired that land and essentially knew about this restrictive covenant, started to develop this land, and then applied under Section 84 of the Law of Property Act 1925. This is a provision which allows landowners to apply to the upper tribunal to modify a restrictive covenant if a number of grounds are satisfied. Now, in this case, the ground in question was that the restrictive covenant was contrary to the public interest. They built these houses on the land, and their argument was that we've got all of these houses built that people want to live in and that are of public utility, and therefore this restrictive covenant is contrary to the public interest. The upper tribunal considered that and agreed and said, all right, if you pay 150 grand in compensation to the hospice, we accept that the balancing act between these competing interests could be better balanced, and allowed the developer to build these to have this modification in the restrictive covenant. The hospice hadn't known about the restrictive covenant, found out about this, and challenged the UT decision appealed all the way up through the Court of Appeal to the Supreme Court. They were successful at the Court of Appeal, and the Supreme Court, just turning to the, the Supreme Court considered the two key issues are, well, the key fact was the developer's cynical approach. Cynical is a term that's used in these property cases to describe a breach which is deliberate with a view to making a profit. And the Supreme Court focused on this cynical breach, and they considered that there were two stages. First, the upper tribunal's decision whether it had discretion or whether it had jurisdiction to make this modification of the restrictive covenant. And in doing so, the Supreme Court held that it wasn't relative to consider this cynical approach and behaviour of the property developer. The only sort of what the UT had to do was to conduct a balancing act between these two competing public goods, public interests. So on the one hand, children in a hospice, there's an obvious public interest there in allowing them to enjoy this open space and this beautiful sort of setting. On the other hand, there is a real public interest in allowing affordable housing. These were affordable homes. So the cynical behaviour wasn't relevant at that stage. At the second stage, which is where the UT then exercises the discretion whether to allow this modification that's been sought, the Lord Barrow's giving judgment for the unanimous Supreme Court was really quite critical, extremely critical of this developer. He found that although he couldn't quite identify where in the UT's decision, he found that they must have gone seriously wrong at some point, such that they'd made an error of law. They'd failed to consider that, first of all, the developer could have applied for planning permission, which would have built on an unencumbered part of its land, so it wouldn't have breached the restrictive covenant. And had it made such an application, the application would have succeeded. So the first point he made was that this land conflict, this horrible and distressful conflict, was entirely of the developer's own making. And the second point that he made was that if the application had been made before starting building, the application for planning permission would have been rejected, of course, because the developer could have simply built on unencumbered land. So he found that it simply wasn't in the public interest to allow developers to willfully breach these restrictive covenants and then come looking to the court for forgiveness. So a very interesting case in restrictive covenant of great importance to anyone developing land or with the benefit of a restrictive covenant. Those are the three cases I was going to talk about. I think the last point I'll make is about a case Sarah mentioned, trope, which is one of my cases. She's right to say it does mean that English courts will apply English rates of interest, not foreign rates. But of course, I think that the English interest rates are discretionary, and I think that the court did leave open the possibility that you can argue for the court to exercise a higher discretionary rate of interest in English law if it reflects. I mean, for example, Sarah was talking about the very stingy rates of the stingy levels of general damages in Spanish law. Part of the reason for that is that interest rates are so high and punitive. So you could make a very strong argument that I think probably would succeed, that the English court should exercise its English discretion as to interest at a much higher rate to reflect the real damages that would be awarded in Spanish law. So those are the cases that I'm going to talk about. I think it's my job to ask if there are any questions arising from any of those cases that we've discussed. Can't see any.
No, I can't see any in the Q&A boxes. No. But if anybody does have any questions, you can email in after today.
See various posts by Sarah about cases that she was right on originally.
Pardon?
I see various posts from Sarah about how she preempted the Supreme Court.
Oh yes, always predicting it accurately. Well, it'll fall to me then. If there aren't any questions, as I say, do feel free to email any of us after today or the respective person that's provided a talk within your practice area, and we'll answer them as best as we can. It falls to me to say Merry Christmas and good luck in 2021. We'll be back with our webinars. We've enjoyed delivering them in what has been a very strange year, but it's launched our YouTube channel. We hope you found it really useful, and we'll be back with a fortnightly programme kicking off 2021. But have a good break, everyone, and if you have any questions in the meantime, do let us know. Merry Christmas.
Thanks, everyone.
Yeah, Merry Christmas,
Merry
everyone.
Christmas.
Merry Christmas.